So the potential client has reached out to you. They've given you their approximate budget and some of their ideas. And based on that and your years of experience, your know-how, your expertise, your industry contacts, you have put all that together into an exceptional proposal that cannot be beat. This is going to make the event fantastic. So you give that proposal to the client and you never hear from them again. Or even worse, the client took your ideas, took your design, and has utilized it and done the event themselves. Or even worse, they used your proposal to price shop with competitors who are now using it and have undercut you. Is that fair? Not really. Is there something that you can do about it? Absolutely. We're going to be talking about that in today's video. Stick around. Hey out there, welcome back. My name is Rob. I'm a wedding lawyer representing wedding industry professionals. And in this video, we're going to be talking about the idea of protecting your proposal, protecting the work that you do prior to actually engaging the client with a contract and an exchange of money. Sometimes, particularly the planners and the designers and the coordinators, in order to theoretically land the client, in order to close on the client, you have to give them a proposal. And that proposal might include a lot of your work product, locations, ideas, themes, designs, a lot of work that comes from your brain. And it's sad when the client takes that concept that no money has been exchanged hands for, and either does it themselves using your plan, or uses it to, essentially price shop other places. Now, for many of you, the idea of performing work, of providing that proposal, of creating at least some design, is a cost of doing business. It's the cost of landing the client. So if one client doesn't accept you, that 5 hours is burned, and then that is worked into the next client that you do close. Okay, so it's a cost of doing business. You have baked that into the cake of your marketing, of your business model. But for the rest of you that this doesn't sit well with, that this grinds your gears and you want to prevent, from a basic standpoint, does the law automatically protect that work, the proposal, when there has been no exchange of money and no promise of any sort other than I'm going to give you a proposal and ask you what you think about it, and if you like it, you'll hire me? Outside of any other thing other than what we just talked about, does the law protect that? Typically not. So in other words, trademark law, copyright law, or some type of patent law is likely not going to protect you there. There's two main ways that we're going to talk about in this video that's going to protect you in this scenario. Two ways in which you can protect the work that you do in designing that event before signing the client up. Okay. The first one is to have the client sign a non-disclosure agreement at the very beginning of the relationship. A non-disclosure agreement is essentially just an agreement that the parties are going to keep concepts, information, data, ideas, know-how confidential. By way of further example, an NDA in this scenario is not only going to keep something confidential, but it's literally going to spell out, you cannot use this to price shop. You can't show this to a competitor. You can't show it to a colleague. So that's what confidential means with NDAs in our scenario. The client it's an agreement between you and the client that the client can only look at it and hang it on the refrigerator, that proposal. They can't use it in any other way. That's the idea of NDAs. So Well, Rob, why can't you just put the NDA language into the proposal? So when the client comes to you, wants you to do the work, you come back, you've done the work, you give them the proposal. Why not have the NDA language in it? And the reason why is typically for a contract to be enforceable, there's got to be some type of mutual agreement by the parties to the terms. So in this instance, the term of confidentiality. Now, not only do you have to have that mutual understanding, that mutual assent, typically it has to be done before the conduct that is the basis for the contract is performed. Otherwise, parties can come back later on and say, well, X, Y, and Z, and the other party can say, well, I never agreed to that. In this instance, it's possible that you can put NDA language in your proposal such that when they accept it, the proposal, they're accepting the NDA. However, in many jurisdictions, that will be very, very difficult to enforce. It'll be very, very difficult to prove that the client is accepting the obligation of confidentiality by accepting the proposal. So it's safer that the NDA, the language of confidentiality that you're wanting to obligate the client to, occurs before the effort is made and the proposal is generated. That's going to be the safest way legally to have the NDA enforced. So again, really quickly, the client approaches you. That's when the NDA is created, and so the client knows that at that point that they're going to receive a proposal that is confidential. Now, how are NDAs enforced? So what's the idea of what happens if the client, even in spite of the NDA, violates it and goes and gives it to a competitor or uses those ideas themselves? So at that point, if you've got a valid NDA, then it's a breach of contract action. You would go to the court and say, I've got a valid NDA, non-disclosure agreement, and I want compensation for the client having breached that. And then, of course, you'll have to explain to the judge or explain to the jury what money you're owed for that. So you could possibly make the argument that I should get full contract value of what the contract would have been had they gone with me. Maybe restitution. In other words, what value I put into that proposal, and that's it. So that's how it would be enforced. And then, of course, you have to actually get the money from the client, because again, a verdict or a judgment is only a piece of paper saying the client owes you money. But anyway, that's how it would be enforced most of the time. There might be rare instances in which you can maybe get an injunction to prevent the event from going forward, but now we're getting into super hypothetical situations. Most of the time, it'll be money damages that you're getting if the NDA is not enforced. Okay, now, or not is the NDA is violated. Okay, so that's the first way that you can protect the concepts in your proposal, is through an NDA signed or somehow agreed to at the start of the relationship. Okay. What's the other way, or what's another way to protect your design concepts? This one is simple. It's to make the client pay for them at the beginning. In this way, if the client goes off and gives it to somebody else, or the client goes off and does it themselves, you're okay, because theoretically you've been paid for that concept. So you, as the planner, the design artist, whoever you are, would need to incorporate that into whatever your fee is, whether it's flat fee, hourly, whatever the case may be, such that if the client doesn't use you, you've still been paid what you think the design was worth, if that makes sense. So oftentimes, I don't want to say oftentimes, but in my anecdotal experience, design artists that want to be paid for their concepts, it's usually a flat fee of X amount. And if the client goes off and uses it or doesn't use it, it's no sweat off that professional's back, because they've been paid for it. They've been paid for it. How this actually works in practice, there's more than one way to skin a cat. So sometimes when someone's paid for their design, it's kind of, in other words, two contracts. So here's my limited engagement. you're paying me whatever a fee is, whether it's flat fee or hourly or whatever it is, for the design concept. Then if you like that concept, you're going to come back around to me and we're going to actually do a more full contract for the actual event itself. And it's 2 different contracts. That's one way to do it. Another way to do it is to have one contract that kind of incorporates both concepts. So you're going to pay X amount upfront. That's going to get you the actual design concept. Take with it what you want or not. If you do want me to actually go forward with the event, other than just the limited design and actually effectuate the event, then you're going to follow the rest of the terms and conditions in this contract. You're going to pay me this installment, this deposit, whatever you're calling it, and you're going to move forward. So again, there are a lot of different ways that you can do this to protect your work product. I would highly advise that you talk to an attorney in your local area, in your jurisdiction, if for lack of a better word. Sorry, it's late in the day. Anyway, that's 2 different ways that you can protect that work product. NDA, and then just having a contract for the concept itself, such that if the client doesn't use you, gives it to a competitor, whatever, doesn't matter, you got paid anyway. So hopefully you found that informative and that you are enjoying the content of these videos. If you do, please be sure to like and subscribe. Hit the notification icon, the notification bell, as the kids say. If you are listening to this on some type of podcast software, please be sure to leave a review, like, and subscribe there. The Wedding Industry Law video series is available everywhere you get podcasts from. And if you've made it this far, super appreciate you. New episodes, new videos every week. And with that, folks, we'll see you next time.